Hi, Nora.
Hi.
I always know it's you before I even see your name because the screen is just green.
Oh,
How are you?
I'm good. How are you?
I'm doing well. Doing well. All right. Well, perfect timing. We'll go ahead and get started.
Okay.
All right. All right. Here we go. We're going to start off with some actually, these are common picturable words. Okay, here we go. Ready? Angle, bridge, dress, horse, ant, brush, drop, hospital, apple, bucket, ear, house, arch, bulb, egg, island, arm, button, engine, jewel, army, cake, eye, kettle, baby, camera, face, key, bag, card, farm, knee, ball, carriage, feather, knife, band, cart, finger, knot, basin, cat, fish, leaf, basket, chain, flag, leg, bath, cheese, floor, library, bed, chest, fly, line, bee, chin, foot, lip, bell, church, fork, lock, berry, circle, foul, map, bird, clock, frame, match, blade, cloud, garden, monkey, board, coat, girl, moon, boat, collar, glove, mouth, bone, comb, goat, muscle, book, cord, gun, nail, boot, cow, hair, neck, bottle, cup, hammer, needle, box, curtain, hand, nerve, boy, cushion, hat, net, brain, dog, head, nose, break, door, heart, nut, branch, drain, hook, office, brick, drawer, horn, orange. All right. I've got a drill here that covers Jelly Belly's official 50 flavors. Here we go. Ready? A&W cream soda, A&W root beer, berry blue, blueberry, bubble gum, buttered popcorn, cantaloupe, cappuccino, caramel corn, chili mango, chocolate pudding, cinnamon, coconut, cotton candy, crushed pineapple, Dr. Pepper, French vanilla, green apple, island punch, juicy pear, kiwi, lemon drop, lemon lime, licorice, mango, margarita, mixed berry smoothie, orange sherbet, peach, pina colada, plum, pomegranate, raspberry, red apple, sizzling cinnamon, sour cherry, strawberry cheesecake, strawberry daiquiri, strawberry jam, sun-kissed lemon, sun-kissed lime, sun-kissed orange, sun-kissed pink grapefruit, sun-kissed tangerine, toasted marshmallow, top banana, tutti frutti, berry cherry, watermelon, wild blackberry. All right. Those are fun. All right, now I've got consonant compounds emphasizing final RT, final RG, final RKS. Here we go. Did they start the first part of the evening with a concert? The Art Mart is near the court. He was curt and short. The port is north of the fort. The dart landed near her heart. Bert played in the dirt. Sal was alert and pert. The wiring is tearing and wearing away. Hiring and firing is a difficult task. Sherry was preparing the meal and sharing the news. Al was daring before entering the arena. The catering company is barring the door. The ordering department is hindering our progress. The dog barks when Cal parks the car. We found 2 corks and 3 forks. He marks the merchandise when he works. May irks Brian when she shirks responsibility. When the coffee perks, he jerks the plug. The fox lurks near the larks, not far from the Ozarks. Right. I have a number drill for you. This is going to give you an age, interest, and loan balance, along with principal limit and home value. All right. So it's like home equity conversion mortgage. All right, here we go. Age 76, interest $2,789, loan balance $67,609, remaining credit line $93,084, principal limit $160,693, home value $332,800, remaining equity $265,191. Age 77, MIP 345, interest $2,924, loan balance $70,878, remaining credit line $97,585, principal limit $168,464, home value $346,112, remaining equity $275,234, age 78, MIP 362, interest $3,065, loan balance $74,306, remaining line or credit line $102,305, principal limit $176,612, home value $359,956, remaining equity $285,651, age 79, MIP 380, interest $3,214, loan balance $78,890, remaining credit line $107,252, principal limit $185,151, home value $374,350, and remaining equity $296,450. Last one, age 80, MIP 398, interest $3,369, loan balance $81,667, remaining credit line $112,439, principal limit $194,105, home value $389,329, and remaining equity $307,662. And there's more, but I'm going to stop right there. All right. I have some basic, sentences that have basic briefs that you learned in theory and more in the lower speed. So I don't even have to, I'll go through and give you the briefs that it focuses on, but you should already know these. So I don't even have to, give them to you. All right. So you're going to hear above, accident, accomplish, actual, ago, American, among, and a half, anxious, apartment, appreciate, appreciation, approximate, approximately, approximation, at all times, at any time, at that point, at that time, at the same time, at the time, at this time, at this, attorney, at what time, at which time, twit, automobile, bathroom, bedroom, beautiful, being, better, burst, certificate, children, cigarettes, continuation, conversation, cooperate. All right, so here are your sentences. And if there's something that you don't know, just let me know and I will give it to you. Okay, all right, here we go. The bird sits high above the street. It was an accident. There is much to accomplish. When was the actual date? That was a long time ago. I am proud to be an American. They were among the proud. The cake needs a cup and a half of oil. I am feeling anxious. She just got an apartment. We really appreciate your help. The time has come to show appreciation. Be ready at the approximate hour. It is approximately 3 o'clock. My approximation is for Saturday. I need water at all times. She could need me at any time. At that point, the date was over. She was thinner at that time. He was not good at that. We both did laundry at the same time. It made sense at the time. I am no good at this. We will adjourn at this time. He is my attorney. At what time did he return? At which time did you leave? She is such a twit. He bought a new automobile. Where is the bathroom? I showed him my bedroom. Lynn is beautiful. It is nice being smart. Mom knows better than anyone. I am so happy I could burst. We are working for our certificate. I am not ready for children. I hate cigarettes. This is the continuation of the first book. We need to have a conversation. The witness would not cooperate. All right, there's more, but I'm going to stop there for this class. My next drill is going to focus on typical objections. The first page is going to cover I object, IB, Your Honor, you know that one, on the ground, OEG. Okay, and it could be in different orders, okay, but that's what it's typically going to focus on with this page. Okay, here we go. I object, Your Honor, on the ground that the question is ambiguous. I object, Your Honor, on the ground that the question is unintelligible. I object, Your Honor, on the ground that the question is compound. I object, Your Honor, on the ground that the question is too general. I object, Your Honor, on the ground that the question calls for a narrative answer. I object, Your Honor, on the ground that the question calls for a conclusion. I object, Your Honor, on the ground that the question has been asked and answered. Your Honor, I object on the ground that the question is leading. Your Honor, I object on the ground that counsel is misquoting the witness. Your Honor, I object on the ground that the question is argumentative. Your Honor, I object on the ground that the question assumes facts, not in evidence. Okay, let's go to the next page. For the first half, you're going to hear, if Your Honor, please, FURP. I object, on the ground. Irrelevant is IR, incompetent, IP, hearsay, HAERS. Okay, and then you're going to hear, if the court please, FURK. Okay, here we go. If Your Honor, please, I object on the ground that the question calls for speculation by the witness. If Your Honor, please, I object on the ground that the question calls for an answer that is irrelevant. If Your Honor, please, I object on the ground that this witness is incompetent to testify about this matter because it has not been shown that he has personal knowledge of it. If Your Honor, please, I object on the ground that this person is incompetent to be a witness because he cannot express himself so as to be understood. If Your Honor, please, I object on the grounds or on the ground that the question calls for hearsay. If the court please, I'll object on the ground that the question calls for inadmissible opinion. If the court please, I'll object on the ground a sufficient foundation has not been laid showing that the witness is qualified as an expert. If the court please, I'll object on the ground that this is not a proper subject matter for expert testimony. If the court please, I'll object on the ground that the witness is basing his opinion on improper matter. If the court please, I'll object on the ground a sufficient foundation has not been laid showing that the witness has personal knowledge about the matter. Okay, so we've got 2 more pages. This next page is going to focus on if the court pleases. So if the court please is FURK. Now, if the court pleases, you can do it 2 different ways. You can either do FURK, come back for final Z, or you can just do FURKS in 1 stroke, okay? So you're gonna hear on the ground, direct examination, DREX, cross-examination, KROX. Let's see here. I object on the ground. Yeah, so that's pretty much, and you know, they're gonna all be in different, you know, you're gonna hear a little bit different objection each time, okay? All right, here we go, ready? If the court pleases, objection on the ground that the proposed evidence is cumulative. If the court pleases, objection on the ground that this is not the best evidence. If the court pleases, objection on the ground that this is inadmissible parole evidence. If the court pleases, objection on the ground that this question exceeds the scope of direct examination. If the court pleases, objection on the ground that this question exceeds the scope of cross-examination. If the court pleases, objection on the ground that this question exceeds the scope of redirect examination. I object, Your Honor, on the ground that this evidence is unduly inflammatory. I object, Your Honor, to the admission of this evidence on the ground that it has not been proved. I object, Your Honor, on the ground that this evidence was illegally obtained. Your Honor, this evidence will consume an undue amount of time and confuse the issue. I request that it be excluded under Section 352 of the Evidence Code. Your Honor, that question calls for disclosure of a confidential communication with my client, and I claim the lawyer-client privilege on behalf of my client. The only one I didn't see and give you is confidential, which you probably know, initial K, final FL. Okay, so this last page is going to be various objections and requests. Okay, so you're going to hear psychotherapist, confidential, initial K, final FL, on the ground. Okay, here we go. I request that you advise the witness of his right to refuse to answer. I move that Your Honor exclude the answer as privileged. I move for a mistrial on the ground that the effect of this misconduct is so prejudicial that a fair trial is now impossible. Your Honor, that question calls for disclosure of a privileged confidential communication between patient and physician. Your Honor, I am the psychotherapist, or I claim the psychotherapist patient privilege. Your Honor, I claim the privilege for confidential communications between husband and wife. Your Honor, that question calls for disclosure of a confidential marital communication. Your Honor, I assign as misconduct counsels showing that photograph to the jury after Your Honor has ruled that it is inadmissible. All right. It's one of my favorite drills. Let's go ahead and start. We'll go ahead and get into literary. How are we doing on time? 5:20. So we're doing good. All right. I will start this at 180, and I will get to 200 because it is literary. Okay. And this is on the criminal justice system. All right. I'm just dating this. All right. Here we go. Ready? A crime is an action that offends the morality of a society and that a society has determined it will not tolerate. The criminal justice system is that system which a society evolves to handle those who commit crimes. The term criminal justice system applies to the entire process from commission of a crime to punishment. This system necessarily reflects the values of its society, not just in the conduct that it punishes, but also in the way that it treats the accused and the criminal. Systems that are characterized by strict enforcement of the laws, by a rapid determination of the guilt of the accused, and by harsh punishment are frequently found in nations that grant defendants few rights. When compared to the United States, these nations are more likely to regiment their citizens, restrict their behavior, and interfere in their private lives. Since its beginning, the United States has regarded itself as a different sort of society. Many of the people who settled the new nation left their homelands to be free from what they considered to be excessive government intrusion. They recognized the importance of restricting the power of government and protecting the individual citizen from the power of the state. Consequently, the states passed the Bill of Rights, which became the first 10 amendments to the Constitution. Those amendments, which grant the person accused of a crime many vital rights, form the foundation of the nation's criminal justice system. Our criminal justice system today, however, is the subject of much criticism. Many members of the public believe that they are not safe, that crime is rampant, that the police are not effective in catching the wrongdoer, and that the system, lawyers, judges, and prosecutors, is excessively lenient. The crime-fearing public that criticizes the courts in this way overlooks a crucial fact. The problems that lie at the root of the crime are not lenient judges or clever lawyers, but instead are such things as poverty, poor education, and the breakdown of the family structure. These are conditions that the criminal justice system cannot and should not be expected to correct. The criminal justice system already has an extraordinarily difficult task. It must strike a delicate balance among the sometimes competing interests in protecting the accused from the tyrannical intrusion of the state, vindicating the public morality by punishing the wrongdoer, and enforcing the criminal laws in such a way as to protect society from future crimes. This is indeed a formidable task. To the outsider, the criminal justice system that has evolved to tackle this difficult job may appear to be a confusing maze. There are numerous courts and several set of criminal laws. Cases in federal court involve the alleged violation of federal criminal laws, and cases in state courts, the alleged violation of state criminal laws. Both federal and state laws divide criminal conduct into two categories: misdemeanors and felonies. Misdemeanors range from traffic violations to such offenses as theft of a small amount of money. A felony is a major crime for which the maximum penalty may be a fine or imprisonment, or both. Felonies include such offenses as homicide, arson, rape, robbery, burglary, and grand larceny. Federal and most state courts are divided into three levels. First, at the lowest level, is the trial court. In that court, the actual trial is conducted and the accused is found guilty or not guilty. At the next level are the appeals courts, and usually there are several such courts. Finally, each state has a Supreme Court, and the federal system has the United States Supreme Court. Within the state criminal justice system, there are generally several different trial courts. The cases that these courts may hear depend upon their jurisdiction. Jurisdiction is a term that refers to the power or authority of a court to hear and decide a particular kind of case. The lowest level courts, for example, often have jurisdiction only over such crimes as traffic violations, criminal trespass, and public intoxication. Other courts hear only more serious misdemeanors, such as petty larceny, while the highest level of trial courts hears only felony cases. In 1967, the President's Commission on Law Enforcement and Administration of Justice issued a task force report on the courts. The commission inquired into the effectiveness and fairness of America's criminal courts and found that the aspects of the criminal court system most in need of reform were the lower criminal courts in urban areas. Because most crimes are committed in the cities, these courts handle the majority of all cases that are tried. Literally millions of arrested persons first appear before these courts, either for trial or of misdemeanor or petty offenses, or for preliminary proceedings in more serious cases. Of the nation's criminal cases, the vast majority are heard in the urban lower courts. These courts often operate with meager facilities, with the least trained personnel, and with the most oppressive workload. Practices by judges, prosecutors, and defense counsel that would be condemned in the higher courts may still be found in these courts. Judgeships in such lower courts are often elected offices. Pressures from friends and interested groups and the practice of accepting campaign contributions from lawyers make impartiality difficult. In those cities where judges are appointed and where the salaries are adequate, the quality of justice is significantly higher. Able and experienced lawyers often find appointed to a municipal judgeship very desirable. Not infrequently, hundreds of applications will be received for one such position. Such qualified appointed municipal court judges may find their quality of justice hampered, however, because their courts are not courts of record, which means the proceedings are not recorded by a court reporter. When a case is appealed from such a court, the case must be retried by a higher court. The appeal is then de novo, that is, the case is tried again. A serious problem with a de novo appeal is that by the time the appeal is heard, witnesses may no longer be available, and the memory of those witnesses who are available may have faded. On the other hand, in a court of record, when a case is appealed, the court reporter records everything that was said in the trial court. This record is submitted to the appeals court along with all the documents filed in the case. The appeals court then renders a decision based on the lower court record. Improvements at the lower court level will have the most favorable reaching effects. If the criminal justice system does not provide the best possible service at this level, we may cast an unnecessary shadow over the entire legal system. The millions of individuals who have contact only with these lower courts form opinions based on their experiences that at best reduce their respect for the system and at worst result in hardening of antisocial attitudes. All right. Moving into jury charge. The subject is fraud and deceit. Okay. I will read this at 225. Actually, this is jury charge. I'll read this at 200. Okay. All right, here we go. Ready? Ladies and gentlemen of the jury, the issues in this case are issues of fraud and deceit. Fraudulent representation, or fraud as the term here is used, may be defined as false statements of material facts in a transaction made by one party to another, made with knowledge of their falsity, or made as positive statements of fact without reference to the truth or falsity, and made with the intent that the other party shall act thereon. When such other party believes such statements and relies thereon, and is induced thereby to enter into a contract or transaction, and the statements are false and damage results to him, then such statements are fraud, which entitles the party injured to recover damages. Fraud is never presumed and must always be proved, and the burden of proof rests upon the parties asserting the fraud, the defendant in the case, to prove by a fair preponderance of the evidence, that is, the greater weight of the evidence, that he was defrauded as claimed by him. If you find the evidence on this question evenly balanced, or that it preponderates in favor of the plaintiff, then you will find a verdict in plaintiff's favor. In order to recover on the ground of fraud or fraudulent representations, the party claiming to have been defrauded must have believed and relied upon the false statements made by the other party in the transaction. And if the party claiming fraud had knowledge of the real facts in connection with the transaction in question and relied upon his own knowledge and information and did not rely upon the statements made to him, then there is no fraud, because the party asserting the fraud is not deceived. In this case, there is no fraud insofar as the contents of the agreement, Exhibit 4, is concerned, because it is admitted by the plaintiff that John Henry read the agreement, Exhibit 4, and knew the contents thereof, and he was not deceived as to what Exhibit 4 contained. The only question of fraud in this case is whether the defendants agreed to execute a promissory note for $30,000 to the plaintiff and delivered Exhibit 4 purporting to be such note, and fraudulently stated to Tyler that Exhibit 4 was a promissory note for $30,000 and was the note referred to in Exhibit 4, and whether pursuant hereto Tyler believed that said instrument to be promissory note for $30,000. If under the rules given you find and believe from the evidence that the defendant Morris, representing the defendants at the time of making the agreement of settlement, represented and stated to Tyler, acting for the plaintiff in this case, that the defendants would execute to the plaintiff, say, promissory note for $30,000, and that later Morris delivered Exhibit 4 to the said Tyler, and then stated to him that said Exhibit 4 was a promissory note for $30,000, and was the note referred to in Exhibit 1, and you find that these statements and making of Exhibit 4 were done for the purpose of cheating and defrauding the plaintiff as claimed, and you further find that Tyler believed that said representations and believed that said Exhibit 4 was a promissory note on which the defendants were personally liable and was the note referred to in Exhibit 4 and relied and acted thereon, then you will find a verdict in plaintiff's favor for $30,000 with interest added as provided for in said Exhibit 4. On the other hand, if you fail to so find from the preponderance of the evidence, or you find the evidence equally balanced on either of these issues, or if you find that Morris did not make the fraudulent representations as claimed by the plaintiff, or you find that said Exhibit 4 was in accordance with the agreement of the parties, or that the said Tyler at the time of the receiving said Exhibit 4 knew the contents and terms thereof, then in either case, such case, you will find a verdict in defendant's favor of no cause of action. If you find a verdict in plaintiff's favor in this case, it will be for the full amount of $30,000 with interest added as provided for in Exhibit 4. If you find a verdict in defendant's favor, it will be the usual verdict of no cause of action. All right, and that was at 200 the whole time. All right. How are we doing on time? 5:30. Okay, I'm going to give you one more. This is the definition of bailment. Okay, and then we're going to go right into Q&A. All right, here we go. I'll read this at I'll read this at 225. Okay, give you a little push. Okay, so bailment. Here we go. A bailment may be defined insofar as it applies to this case as a contract for the delivery of personal property for safekeeping and is a contract which is contemplated to be beneficial to both parties thereto, where the bailment is beneficial to both parties, as in this case, the bailee, the defendant in this case, is liable to the bailer, the plaintiff in this case, for the failure to exercise ordinary care or reasonable care in the absence of a special agreement to the contrary. You are instructed that the defendant was negligent if he failed to exercise the degree of care in protecting the plaintiff's property that an ordinarily careful and prudent person would have exercised under the same or like circumstances. If the defendant used ordinary care and diligence, then he is not liable. But if he failed to use the ordinary care and diligence that an ordinarily prudent person would have used under the circumstances, then he is liable. The burden of proof is upon the plaintiff to prove by a fair preponderance of the evidence that there was a negligence of duty that the defendant owed to him, and it was neglect when the defendant became a bailee of this automobile. So that was at 225. Okay, we'll go ahead and move into Q&A. I'm going to give you the strict Q&A first. And this is defense. Actually, no, this is plaintiff. Sorry about that. So it's strict Q&A. Okay, now I'm going to read this one time at 180, again at 200, and again at 225, okay? It's 2 pages. So you're going to hear 22 caliber pistol, marijuana, M-A-R-N, Marn, Officer Arlen, Senior Deputy Arlen, William Johnson, Patricia, Sheriff's Department, Ralph Baxter. Okay. All right. First time will be at 180. Here we go. Did he then proceed to search the car? No, he didn't. Did someone else search the car? No. While you were in the area, was the car searched? Yes, it was. By whom? Senior Deputy Arlen. Were you present and watching him at the time? Yes. Did you observe him find a .22 caliber pistol in the car? No. Did you observe him find a bag of marijuana in the car? No. Did you observe him appear to find what appeared to be a .22 caliber pistol? No. Did you observe him to find what appeared to be a bag of marijuana? No. Did you observe him to find what appeared to be a bag of white powder? No. Do you know what was found in the car? I was told by Officer Arlen what was recovered. What did he tell you? He told me he recovered a handgun and a bag of white powder. Anything else? That is all he said at that time. He didn't mention marijuana? No. When did he tell you he found those items in the car? Right after he searched it. Which was along the side of the road? Yes. Did he show such items to you? No. Was anyone else present and observing while he was searched? Other deputies from the sheriff's department. Anyone else? Not anyone that could see. Who else was present regardless of whether or not they could see? Ralph Baxter. Was there anyone else? William Johnson. Was there anyone else? No. When did you meet Mr. Johnson for the first time? I met him in about June, I believe. Who introduced you to him? I met him at a motorcycle race. Was anyone with you at the time? No. Was anyone with him at the time? His sister, I believe. What's her name? All I know is her first name. I don't know her last name. What's her first name? Patricia. Is she married as far as you know? She is divorced or separated. Do you know where Mr. Johnson lives? No, I don't. Do you know where he works? No, I don't. Did you ever know where he lived or worked? Yes. Do you recall where that was? I don't know the address. It was a dirt road. Do you have anything to which you might refer to refresh your memory as to Mr. Johnson's last known address? No, I don't. When did you last see Mr. Johnson? January 25, I guess. I may have seen him, but I haven't spoken with him. All right, so we're going to do that again at 200. Okay. I'm just stating this. Oftentimes I'll say to myself, oh, I'll do it later, and then I forget, and then I don't want to repeat myself in another class with the same material. All right, here we go. So 200. Did he then proceed to search the car? No, he didn't. Did someone else search the car? No. While you were in the area, was the car searched? Yes, it was. By whom? Senior Deputy Arlen. Were you present and watching him at the time? Yes. Did you observe him find a .22 caliber pistol in the car? No. Did you observe him find a bag of marijuana in the car? No. Did you observe him appear to find what appeared to be a .22 caliber pistol? No. Did you observe him find what appeared to be a bag of marijuana? No. Did you observe him find what appeared to be a bag of white powder? No. Do you know what was found in the car? I was told by Officer Arlen what was recovered. What did he tell you? He told me he recovered a handgun and a bag of white powder. Anything else? That is all he said at that time. He didn't mention marijuana? No. When did he tell you he found those items in the car? Right after he searched it, which was along the side of the road? Yes. Did he show you such items to you? No. Was anyone else present and observing while he was searched? Other deputies from the sheriff's department? Anyone else? Not anyone else that I could see. Who else was present regardless of whether or not they could see? Ralph Baxter? Was there anyone else? William Johnson? Was there anyone else? No. When did you meet Mr. Johnson for the first time? I met him in about June, I believe. Who introduced you to him? I met him at a motorcycle race. Was anyone with you at the time? No. Was anyone with him at the time? His sister, I believe. What's her name? All I know is her first name. I don't know her last name. What's her first name? Patricia. Is she married as far as you know? She is divorced or separated. Do you know where Mr. Johnson lives? No, I don't. Do you know where he works? No, I don't. Did you ever know where he lived or worked? Yes. Do you recall where that was? I don't know the address. It was a dirt road. Do you have anything to which you might refer to refresh your memory as to Mr. Johnson's last known address? No, I don't. When did you last see Mr. Johnson? January 25, I guess. I may have seen him, but I haven't spoken with him. All right, so we'll do this last time at 225, okay? All right, here we go. Did he then proceed to search the car? No, he didn't. Did someone else search the car? No. While you were in the area, was the car searched? Yes, it was. By whom? Senior Deputy Arlen. Were you present and watching him at the time? Yes. Did you observe him find a .22 caliber pistol in the car? No. Did you observe him find a bag of marijuana in the car? No. Did you observe him appear to find what appeared to be a .22 caliber pistol? No. Did you observe him to find what appeared to be a bag of marijuana? No. Did you observe him to find what appeared to be a bag of white powder? No. Do you know what was found in the car? I was told by Officer Arlen what was recovered. What did he tell you? He told me he recovered a handgun and a bag of white powder. Anything else? That is all he said at that time. He didn't mention marijuana? No. When did he tell you he found those items in the car? Right after he searched it, which was along the side of the road? Yes. Did he show you these items to you? No. Was anyone else present and observing while he was searched? Other deputies from the sheriff's department? Anyone else? Not anyone that I could see. Who else was present regardless of whether or not they could see? Ralph Baxter. Was there anyone else? William Johnson. Was there anyone else? No. When did you meet Mr. Johnson for the first time? I met him in about June, I believe. Who introduced you to him? I met him at a motorcycle race. Was anyone with you at the time? No. Was anyone with him at the time? His sister, I believe. What's her name? All I know is her first name. I don't know her last name. What's her first name? Patricia. Is she married as far as you know? She is divorced or separated. Do you know where Mr. Johnson lives? No, I don't. Do you know where he works? No, I don't. Did you ever know where he lived or worked? Yes. Do you recall where that was? I don't know the address. It was a dirt road. Do you have anything to which you might refer to refresh your memory as to Mr. Johnson's last known address? No, I don't. When did you last see Mr. Johnson? January 25, I guess. I may have seen him, but I haven't spoken with him. All right. Hello, Donna. Glad to have you with us. How are we doing on time? 5:43. Good. All right. Now, let's go ahead and do some colloquy. Okay? I'll read this. This is colloquy, so I'll read this at 200, okay? All right. Here we go. People versus Monty, Halleg, and Hawkins, and People versus Varla. The record reflect each of the defendants are present, represented by counsel, district attorney is present, investigating officer is present. And is there anything we need to do before we bring the jurors in? Your Honor, apparently they want to do a 402. I'm seeking the admission of the statement of Mr. Halleg pursuant to 1220 of the evidence code of Mr. Halleg when he was interviewed by Detective Anderson. And this is page 6 of Detective Anderson's report, and it is dated 8/31 of 2014. The report indicates that when he interviewed Mr. Halleg told him that he knew the victim because he had seen him in the past, and he stated that he had played football with him for several years. I believe they are relevant. Is the DA even going to bring this up? I'm not getting into any of the statements of Mr. Halleg in my direct examination. Okay, then we don't need to go into it unless you are going to call him for one of your witnesses. I am, Your Honor. We'll deal with it then, okay? Okay, no reason to deal with it today. Perfect. Anything else? Your Honor, just along the same lines, I take it we're not going to get into any of these statements by any of the defendants through this witness today. Don't ask me. Well, no, I'm asking so that if we are, I think we need to address it. No, Your Honor. Okay. Okay, good enough. Let's bring in the red jury followed by the blue jury. Okay, the bailiff just told them 9:20. Of course, it's typical of what's going on. All of them are here but two. Do I have time to run to the... Sure, go ahead. Back on the record. Going back on the record. In the case of People versus Monty, Halleg, and Hawkins, and People versus Varla, the record reflect each of the defendants are present, represented by counsel, the district attorney, the investigating officer is present. We're on the record, counsel. The record reflects that all are present. Is there anything else we need to do before we bring the jury in? No, Your Honor. No, Your Honor. Let's bring in the red jury followed by the blue jury. Going back on the record, in the case of People versus Monty, Halleg, and Hawkins, and People versus Varla, the record will reflect each of the defendants are present, represented by counsel. The district attorney is present. Investigating officer is present. All members of each of the respective jurors are present. And at this time, investigating officer can return to the stand, and we will continue with the examination of the officer, and you may continue. Thank you, Your Honor. Now, Detective Anderson, one of the things we discussed last night, or I'm sorry, yesterday, I guess it was Thursday, during your testimony is the search of the Hawkins residence up on View Street. Do you recall that? Yes, sir, I do. And you indicated two of the items that were seized were an address book and a letter. Is that correct? Yes. May I approach, Your Honor? You may. Showing you People's 37. Is this the address book you were speaking about seizing? Yes, it is. Could you return it to that envelope, please? And is this the letter you seized from that residence, People's Exhibit 38? Yes, it is. I believe you also seized some clothing from the residence. Is that correct? Yes, sir. May I approach again, Your Honor? Yes, you may. People's Exhibit 33 is a black t-shirt. Was that seized from the Hawkins residence? Open it. Is it sealed at this time? Yes. Is that your handwriting on the front of that? Yes, it is. Okay, that was placed there when you seized this item? Yes, it was. And People's Exhibit 34, is this a pair of black Levi's that were seized from the Hawkins residence on September 2nd, 2014? Yes, it is. When Salvador Varla was arrested, you seized a pair of Vans tennis shoes that he was wearing. Is that correct? Yes. When you were out at the crime scene collecting evidence at the crime scene and examining the area for physical evidence, you did an examination of Mark Walker's body and his clothing and shoes. Is that correct? Yes. Did you note if there was any dust or dirt on any of his shoes or clothes? None. Okay, thank you. You may continue. Now, you looked at his shoes to determine whether or not his shoe prints could have possibly been left at the crime scene in the dirt? That's correct. Did you see any dirt on the soles of his shoes? No. Did you examine the left rear tail light assembly to the trunk of Mark Walker's vehicle? Both of them, yes. And did you find anything unusual about one of the one of the rear taillight assemblies? Yes. Which one? I believe both of them, but the left more than the other. What did you note that was odd about the left rear taillight assembly? That the plastic wing nuts that hold the taillight assembly onto the body of the car, all the wing nuts had been removed and the taillight assembly had been pushed out as far as possible from the inside. Okay, all right, nothing further. Thank you. In examining the shoe prints that were in the dirt, you noted in your report that there appeared to be 3 other styles that did not belong to the police officers at the scene. Is that correct? Yes. And those were the shoe prints that were photographed? Yes, they were. Okay, behind the victim's vehicle, there appears to be a ledge or a ridge that goes down. Is that correct? That we see in these photographs in People's One? Yes. What's down behind there where the victim's vehicle was backed up into? A lot of trees and brush, and basically like a 40, 50-foot drop off, and goes down to a wash area. Did you examine down below in the wash area? Yes, I did. Okay, we're looking at People's 1B up on the monitor. It's been disconnected, counsel. I hope I knew what I was doing. Okay, down behind where the victim's vehicle is, you indicated there's a wash area? Yes, is that one? I'm attempting to focus on that. Do you see where I'm looking on this photograph that's up there at this time? Yes, ma'am. Down in this area down here? Yes. Did you examine that area for evidence also? Yes. Did you do that night, or did you go back there on a different day? I did a little bit that night, and then I came back another day and checked it out. Is it true there's a bunch of old tires and other garbage that are down in this area? A lot of trash, a lot of concrete, broken up concrete dumped down there. Okay, continue. You attended the autopsy in this case, is that correct? Yes. And you're aware that 4 projectiles were recovered? Yes. And that there was evidence of 5 gunshot wounds to the victim? Yes. Okay, thank you, Your Honor. Nothing further. Go ahead, counsel. Did you attempt to locate a 5th projectile? Yes. What did you do to locate a 5th projectile in this case? The entire area where the dirt area is, the brush area by the vehicle, I went back with a metal detector. Okay, now we're at 5:51, so I'm going to finish this. There's about 5 pages left, and I'm going to read this at 2:25. Okay, here we go. And when was that done? I don't recall the exact date, either the day of the autopsy or maybe the day before. And did you have any success with the metal detector in locating any projectiles of any sort? Not projectiles, no. What area did you cover with the projectile or with the metal detector looking for a projectile? That entire area where the vehicle was, that dirt area. And down below? No, not too far down because it's straight. It's almost like a almost straight drop. Did you cause any of the area that was out in the street by the dirt median to be searched also? Yes. What did you do? I searched that whole area with a metal detector. In the dirt median? Yes, like left and right of the victim's vehicle. Up in this area here, that's in the center of photograph 1B. Not where the van is, but where the victim's vehicle is parked. Okay, in the dirt area? Yes, that dirt area there. What about the center median strip? Did you look there? No, I don't believe so, no. The area that surrounds where the victim's vehicle is located, did you cause or order that a search be done? Yes. And who did you delegate that job to? My supervisor, Jim Rossfield. Sergeant Rossfield? Yes. Were you present out with him when that area was searched? No, I wasn't. I have nothing further at this time. Thank you. If I may, Ms. Sandrin, I have a few questions I would like to ask the detective before you pick up your recross. Okay, fine, Your Honor. Thank you. Good morning, Detective Anderson. Good morning. You indicated that at some point subsequent to your initial search, you went back out to the scene. Is that correct? Yes, Your Honor. And if the autopsy would be on the 31st, it would have been on the 31st or on the 30th of August, 2014. Is that you went back out, correct? I believe so, somewhere around there, yes. On that date of this incident, on August 27 of 2014, you also searched the scene. Is that correct? Yes. And you were there from approximately 9:25 p.m. on the 27th until 2:53 a.m. on the 28th, correct? Yes. So you would have been there when it was dark out. Is that correct? Yes. So the search that you conducted from the evening of the 27th to the morning of the 28th would have been in the dark with the assistance of flashlights and headlights of units. Is that correct? Yes, Your Honor. During that evening, you didn't use a metal detector at any time, did you? No. It wasn't until that subsequent date that you went out back out to look for this projectile, correct? So, and Mr. Mitchell had mentioned that this was missing because only 4 were located somewhere in Mark Walker's body, correct? And that would be a few days after if we assumed it was the 30th or 31st, correct? I believe it might have been on the date of the autopsy. Okay, so if that autopsy was on the 31st, it would have been about then, correct? Yes. Thank you for your indulgence, Ms. Sandrin. Okay, thank you. Now, you assisted your ID tech, Robert, in searching the trunk of a vehicle. Is that correct? Yes. In searching the trunk of the vehicle, did you find any strike marks in the trunk of the vehicle? No, I didn't. And can you please tell the jury what a strike mark is, if you would please, just very briefly? Just in the trunk area, I would have been looking for some type of indentation in the metal or maybe a tear in the carpet where the bullet would have struck and maybe bounced off. Okay, now after you were out at the scene, you went out and spoke to Mr. Walker's stepfather and mother, is that correct? Yes, ma'am. And you spoke briefly with them to find out what his whereabouts was then? Yes, ma'am. And you had a conversation with Mr. Codhay at that time, is that correct? Yes. And he indicated to you at some point in time, he recalled that Mr. Walker, his stepson, had a wallet on him, is that correct? Yes. And the color of that wallet that he indicated to you was what, if you recall? I don't think he was for sure. He just said it was like a blue or a black nylon type. Okay, I'm sorry. Go ahead. Nylon with some gray on it, correct? I don't recall right now. Page 1 of your report dated, I believe this is your initial 9514. Page 1 of the narrative, line 19. Okay, yes, it's gray and black nylon type wallet. But at some point in time after you had contact with them, you subsequently got some information back and went out to Mr. Monty's residence, correct? Yes. And when you went to Mr. Monty's residence, you had contact with his father, correct? Yes. And you didn't tape record any conversation you had with either Mr. Monty's father or the Codhay family, did you? No, I didn't. And when you went out to Mr. Monty's residence, he was arrested, correct? Yes, ma'am. And that was approximately 6:00 p.m.? Yes. I have no further questions. Counsel, between the time that he was arrested and the time that Mr. Varla was arrested, did you have any contact with Mr. Halleg or Mr. Hawkins? No, I didn't. Did you find any other fingerprints on the vehicle besides, to your knowledge? To your knowledge, were any other fingerprints matched on the vehicle besides Mr. Monty's? No. So the only information you had regarding suspects between the arrest of Mr. Monty and Mr. Varla would have been whatever information you got or developed during your course of contact with Mr. Monty, correct? That's correct. At some point in time, then, Mr. Varla is contacted and arrested, correct? Yes, sir. And at that point in time, did you go out to the residence and have a conversation with Kimberly Speck? Yes, I did. All right, so that's the end of that one. What are we doing? Oh, we've got just a couple more minutes. So what I'll do is I'll read this now I'll go down to 200, okay? And hopefully that will seem a little slower. All right, here we go. Back down to 200. Here we go. Now, we are here with regard to a lawsuit that basically arises out of the sale of some property that you owned in the Colorado Springs area, right? First of all, do you recall the particular transaction that we are here about today? Yes. When was that sale? Oh, let me see. Approximately in 2007. Do you recall basically the month? I can't, no, I don't remember. Do you remember whether it was in the summer or the fall, the winter? It was in the winter. And where was the property located? It was located in Colorado Springs. Do you remember what street it was on? Palm Road. Do you by chance remember the address? No. Yes, sir. What is it? 24991? No, 24993. Now, how long had you owned this particular property before you placed it up for sale? Approximately 4 years. And can you give me a basic description of the interior of the house? It was a 5-bedroom, 2-bath home. How many square feet did it have? Approximately 3,000. Did it have a garage? Yes, it did. And was it a 2-car or a 3-car garage? Yes, a 3-car garage. Did it have a family room and a living room? Yes, it had a living room and a family room. And did it have a fireplace? Yes, sir. It had 2 fireplaces. And as far as the exterior, were there any improvements, such as a swimming pool or anything of that nature? Improvements were a patio cover, some brick work in the backyard, a 38-foot pool, and a jacuzzi. Had you done that work yourself, or did you have it contracted? I had it done. Who did you list the property with for sale? Greater Denver Realty. And was there any particular person that you listed it with? Leah Anderson. How did you come to list the property with Mrs. Anderson? I'm trying to think. Let's see. I believe Leah's card was left on our front door, and I also knew Leah through a friend that I went to high school with. Go ahead. I went to school with a friend who gave me Leah's card and number. We were able to reach her through her office. We bought our home through Leah. When we were ready to resell, we asked Leah for her assistance. I see. Do you remember what the purchase price of the residence was? $598,000 approximately. And what was the residence listed for at the time it was sold in 2007? I believe it was $475,000. And do you recall whether it was placed on a multiple? Yes. Listing? Yes. It was a multiple listing. How many days was the residence on the market before it was sold? 3 days. And what was the selling price, Mr. Stevens? Do you remember? $471,900 to be exact. All right. We're right at 5:59. Go ahead and unmute everyone. Well, how'd you guys do?
200 was great after 225. It felt so good.
Good. Good. Is that how you felt, Nora?
Yeah. I really struggled with the, what was it, colloquy?
Yes. Yes, the colloquy. Well, yeah, and if you want, I can try to get more material that has colloquy. It's probably just because we don't do it as much. So, you're adding in the sign changes. And when we go to mark, the sign changes are not considered like one, even though you're hitting something. We mark every 25 words. So it makes total sense. If there's a lot of colloquy, or even a lot of Q&A, just Q&A, fast back and forth Q&A, we don't count the sign changes. So, that makes a big difference. Definitely. You figure if somebody's giving a long, drawn out answer, we're counting all the words, and every 25 words is a slash, but we never count sign changes. We're not supposed to. And so if you've got a lot of fast QA, it's going to make a huge difference, because you're still hitting that sign change. So keep that in mind, that makes a difference. Just like multisyllabic words, like if you've got a word that you're having to stroke out, 4 or 5 strokes, that's still considered one word. Even like, words that, like compound words, that if it's one word, it's still considered one, even though it might be a compound word.
If it's hyphenated, is it the same thing? If they hyphenate it, is it one word?
Yes. Yep. So you take all that into consideration. I think that's why a lot of times people get frustrated because they're like, oh, I'm not writing well today. But really, if you look at it, it really depends on the material, has a lot to do with it.
Yeah. At the conference, we took a mock CSR, and they told us that, right, it's 200 words a minute, but they do have a limit as to the amount of syllables they can have in each minute. And I was just like, phew, that's so helpful.
Yes. Yes, it is.
That wouldn't include sign changes.
Yeah. Yeah, I know. It's interesting that they don't, but it's nice to know that the state test does that. And they also say they will never speak louder. They'll never speak faster than 200, but they do, like they'll say, we may only read it 170, 180 if we want. So yeah, I know. So talking about the state, you took the test Tuesday, right? Yesterday?
I took the 2 written tests yesterday. I felt like the English was beautiful. Like the English test, I just zoomed right through it, and I felt really confident about that. I mean, there's probably a couple of things I got wrong, but I think I passed it. And then on the business practices, I felt like about every other question, I was like, I've never seen this question before, ever. I just was at a loss. And I tried to pick the most logical or best answer, and I knew each time that's probably wrong. Yeah. So I've got to go back and study some different things, and we'll see. But I think I'll retake that one.
Yeah, but if you get your English out of the way.
Yeah, one less thing.
That's right. You're just picking them off, and now you know what to expect. You know,
Yeah.
you have to take the, you know, the professional part over again and the procedures, and now you know, like what the, you know, what
I was so concerned about it, and it took me half an hour, like 30 minutes, and it's a 2-hour test. I went right through it. So hopefully I did not fail. Hopefully I just didn't blow it, but I felt really good about it.
Oh yeah, if you finish that in a half hour, oh absolutely.
Yeah.
Oh, I'm so happy. You'll have to, did they say how long?
They said probably only 2 weeks.
Oh, awesome.
I'll tell you, win or lose, I will tell you.
Oh yes, you have to let us know.
Yeah.
I was thinking about you yesterday.
Oh, thanks.
Yeah, I was thinking how funny it was that they had that test on Halloween, you know?
I know. Well, and that's the thing. I could have taken it earlier, but the instructions on how to register were vague and ambiguous. And so I was waiting for more information to come to me, and then realized only like a week and a half ago, wait, I think they're talking about this thing. So I called, and yes, I had everything.
Oh, wow.
I couldn't do it in San Diego. I had to go to Orange County to do it. So, but anyway, it worked out.
Good. Oh, I'm so happy for you.
We'll see.
Yes.
One thing down would be great.
That's right. That is exactly right.
Then cut my flashcards in half.
That's right. Yeah, then you could just toss them. Oh, I know. It's so good to get that letter in the mail and that says pass, you know?
Yes.
Oh, I have to tell you guys a story that happened to me when I took the state test. So I think I told you, you know, it used to be back-to-back 2 days. And so the first time I went to the state test, I took the academics and I took the machine, and I felt very strongly, I felt great about the machine, but I was like hesitant on the academics. So I get my results in. I passed the academics, all of the, you know, the legs of the academics, but I did not pass the machine. I couldn't believe it. I was shocked. So I asked for my test and my notes. Well, what had happened was I took my time, and this is before you guys computers. Like you would show up and they had typewriters like in this ballroom, you know, like 500 typewriters, and they showed you where you were going, and you got a little stand for your notes, and you'd flip your notes, and you had to type the whole thing. So, you know, not only did you take it on your machine, then you had to go and take your notes and, you know, manually type them. So I was looking at my notes and my transcript, and first of all, I took my time, and I shouldn't have, because I didn't have time to proofread, but I felt really good. So I thought, oh no, I got this. Well, I had accidentally taken 2 flaps and like went up 2 flaps, and I missed all of, you know, and each Q&A sign change was right. Yeah. So I missed, what did I miss? 90 on the first time I did. I was so bummed out, and I had to wait 6 months because they only gave the test every 6 months. I was so mad. So that second time I went in there, and it was up. Oh, well, let me just tell you. So, Mr. Black, he was the one that was in charge of this whole thing. He walked in on my test. There was a door behind the panel. Like, let's say the readers are here. There's a door. He accidentally walked in on right in the middle of the test. In fact, Susan was one of the readers, and from Sage. And she said they just kept reading. But after it was over, they asked us, do you guys have the choice? Because he opened the door, looked in, and he like shut the door. But I just kept writing. And the girls like next to me, they stopped writing. And I just kept telling myself, right, 'cause I'm not waiting another 6 months, you know? So they told us, you have the choice. You can hand us your notes now and come back, and we'll have a retake in like a week just for your group. Or you can go in and type it if you feel okay. And I was like, nope, I'm typing this. I'm not going to give this up, you know? And because what about if the next, I felt like it was a good, you know, like I got it and it was good. So I took my chances and I passed.
Yeah.
I felt so bad though. The girls next to me were, you know, I mean, I didn't know them personally, but they were so, you know, but I just remember thinking, okay, I'm not going to wait another 6. I almost had to get mad, you know, like I'm not waiting another 6 months.
Yeah.
No way.
It would be so much harder to do that way. I don't know how anybody ever did that, the pressure.
But you know what? I think you guys have a different challenge that we didn't have, because I feel like you guys are really hard on yourself. Like you look at your notes, and like if everything isn't like coming up on your dictionary that your heart, like you feel like, oh, I did miss strokes. But that's why I'm always reminding everybody, like, as long as you can read your notes, that's all that matters, you know? Because I mean, we had to read every single word. We couldn't rely on the dictionary. So I feel like, you know, sometimes students might take longer because they feel like, oh, my translates were my
It's not
percentage.
clean.
Yeah.
Yeah.
And it's like, as long as you can read your notes, and that's all that count. That's all that matters, you know?
Yeah.
So just remember that. Remember that test is not a real-time test, you know?
Yeah. Thank goodness.
Yeah. Yeah. So anyways, I'm excited for you guys.
We'll see what happens.
Nora, you're going to be there too.
Yeah.
You're there now. So I can't wait for you to take. Now, did you sign up for the academics yet?
I did not know.
Okay. I thought you were going to sign up for the RPR. You were talking about signing up for the RPR academics or.
Yeah. No. I haven't gotten there yet. No.
No worries. Just keep us posted so we can be rooting for you.
Yeah.
Yes. So, all right. Well, you guys have a great night, and thank you for attending live. And then I will see you, hopefully, if you can, come on Friday morning at 9. Okay. All right.
I should be able to make it this week, so.
You can or you can't?
I should be able to.
Yay!
Yeah.
Yay! Good. I love to have you guys in here. So, all right. Well, then I'll see you 9 o'clock on Friday.
Mhm. Yeah.
Okay.
Okay.
All right. Bye, guys.
Bye.
Bye.